Thank you everyone for being here. It's always very fun to catch up, and it's good to see everyone here in person, catching up, socializing, and we can definitely do that more once the CLE is over. The CCBA is excited to welcome Howard Marshack as he shares his experiences and perspectives from over 35 years of practice in family law. Howard is an experienced litigator, having litigated cases of various complexities in court for over 30 years. He's also an experienced mediator and a trained collaborative law practitioner. Howard is a well-respected member of the Clark County legal community, and we are so pleased he has agreed to present for us. For everyone who is here in person, just be sure to sign in on the sign-in sheet in the back to get credit for your CLE. If you are present here on Zoom, feel free to email Lisa Darko to confirm that you're in attendance. And without that, Howard, the floor is yours.
I'm honored to be here. I'm an old retired guy. I've been retired over 4 years, and you pull me out of my holes and talk about my career, which I'm very proud of. I have prepared remarks, and I have to talk to a double sign because you guys are very late, and we have to get of speech in here. But I want to start with what I planned to say at the end. I retired 4 years ago, and I had no plan except how to shut down the practice. I didn't know what I would do to be active, how I'd stay in contact with my colleagues. As Judge Nichols says, I'd live on a fixed income. But these have been the happiest years of my life. So if you're afraid of retirement, stay afraid, stay working. I'll take care of all the enjoyment in life. Tom Phelan gave a talk like this a couple months ago, and I want to give credit to him because I was surprised that when I attended, he did such a very good job, and I was surprised that they would ask me to come and do what he said all over again. He gave me a lot of these ideas that we're going to talk about today. And Gino is a fantastic attorney. And I don't know if he's fully retired. It sounds like he's fully retired. One of the subjects that he talked about was mentors. And he called on me and said, "Who was your mentor?" And I said, "Ken Weber." But since then, I've thought more about it. I've had at least 5 mentors. Ken Weber, I don't know how many of you knew him, but he had an encyclopedic mind. He could write a treatise, a 3-volume treatise. Let's see. This one. It only took him 16 years because the law kept changing faster than he could write. But if every family law lawyer that don't have this book, go get it. Before him, I had Judge Dean Morgan as a mentor. I worked for him as his bailiff for almost 2 years. And very few of you in this room are old enough to have met Dean Morgan. He was a scholarly guy. He was easy to converse with. He worked very hard and tried to get fair decisions. As his bailiff, I was unique because I was the only bailiff that was going to law schools. And so he would have me. How many here know what the Decennial Digest is? Okay. The Decennial Digest is a regional reporters. They're this thick and they capture the law in every 10-year period. And he knew the law. But he wondered what some judge, and he didn't care what state, did with a similar fact pattern. And I had to go read those books to figure out if they had the same fact pattern, so I could report to him what that judge did. And that was a fool's errand. But he was brilliant, good to work for. He later was appointed to the Court of Appeals. And when he was been on the Court of Appeals for a while, he liked to come back to Vancouver from time to time. And he would give presentations. And I couldn't make one of them, so I left him a note. And he read it to the people who were in attendance, and it said, Judge, I've been reviewing your decisions, and I find that your most well-reasoned decisions are those that you signed off without comment. So, that was fun. Ken Weber, my second mentor, and the one I mentioned first, when he passed away, somebody you all know very well, Scott Hornstein, became my mentor. He doesn't know him. I'm grateful he's not here to hear this in person. But I admired him for his work ethic and his friendship. And he gets results that are impossible for other attorneys. I mean, Bob, where is Bob? Right there. Wouldn't you agree? He would pull rabbits out of the hat, and always with class and straightforward, no theatrics, just a good attorney. One more thing about Ken Weber. He got me involved with the Bar Association. I joined the Family Law Executive Committee and served there for 12 years. And that was a total pleasure, opened my horizons. He also got me involved with the Family Law Council of Community Property States, which I'd be surprised if many of you know what that is. That was an organization that not was sunsetted involuntarily, but it sunsetted. But there's 9 community property states, and they would send delegates and go from one community property state to the other for annual meetings. And they would compare, they would select a topic and say, well, how does California address this topic? How does Nevada? How does Washington? And I was involved with them for 16 years. And that was just a fantastic experience. And I appreciate Ken for opening up those horizons. My next mentor is Dan Lieber. How many of you know Dan Lieber? Yeah. She was not all that well known to me until I asked her to be my attorney when I was going through my legendary divorce. She was the first person I interviewed, but she really wasn't the top of my list. And I was there in her office with her 2 huge dogs roaming around the office. And in 10 minutes, I said, I'm not going to interview anybody else. Would you be my lawyer? And she did a fantastic job. She outlasted the 4 other attorneys that were opposing this. As a practicing lawyer, I was very proud of the set of interrogatories that I would send out. Ken Weber helped draft them, and we refined them, and we thought they were the standard set for the county, because my clients kept getting them. Well, as Danny's client, we received my set of interrogatories. And it was then looking at them that I realized how poorly written they were. And I gave fairly flippant answers to them, and Danny wouldn't have that. So we gave serious answers to serious questions. And it's always good. At trial, she was a master, no theatrics, straight ahead, forward. Couple of regrets. She didn't get for me the chiming clock that I wanted. Otherwise, it was a very good result. And she had to tell me to sit down and behave twice during our trial. As an attorney, the hardest thing I thought for clients when we prepare for trial is going through their testimony, making sure they feel relaxed, tell the truth, listen for the question, testifying is a breeze. I couldn't stand it when I was hearing other people testify. And that's what we have to tell our clients, be prepared for that, sit still and behave. Don't make me tell you in court. The last mentor I want to talk about, some of you may have heard of her, she's Nancy Ritz. She has an amazing ability to connect with people, that she do. And she is able to find middle ground where I didn't think it was possible. The way she works with people, the way she teaches classes, she introduced me to collaborative law. I was very reluctant. I said, this will never happen. But we had numerous collaborative law cases together. They were always a pleasure. And I can tell you that, in my opinion, collaborative practice is faster, better, cheaper for almost everybody going through divorce. Even some of those that you might not think will make it because somebody's just entrenched. Nancy has a way of working with people, coming at them from this angle, that angle, letting them know that she understands their perspective. And it's a pleasure to have watched that. And of all the things I admire in my mentors, I can never copy what they do because you can't be somebody else. You have to be true to your own personality. And so you just have to appreciate them, what they do your best to incorporate that in yourself. Let's see. Talking about, this isn't exactly a role model, but I'm going to bring out a book. How many of you have read this book? Okay, you got a treat coming in. This is Juliet Lako's book, Divorce List. And I couldn't incorporate it in my practice because it came along too late in my practice. But I read it and I thought, this is a gold mine. If I were practicing today, I would buy this by the dozen and I would give it to my clients. And I give it to my clients because it helps them help themselves. It helps them help me, and helps the trial process. It is everything you want your clients to know about the process and about how to take care of themselves and how to be a good team member on their case. And when I say give it away, I don't mean that you'll lose money. In my old practice, I used to give away a book called Dinosaur's Divorce when I was representing parents that had young kids. And Dinosaur's Divorce is this wonderful book that a parent could read to a child about parents separating. And it's everything a judge wants children to know, or a psychologist wants children to know about the divorce process. Everybody loves you. This isn't your fault, but it's said at a child's level. And when I gave that book away, it was still available for $8.99, Amazon. I'd spend 5 minutes talking to them, and I charge them more than that money that I paid for that 5 minutes. And this is $15.99, and you will charge more money in the time it takes you to explain, this is a book I want you to read, and this is why you should read it. All right, that's all the props I have for today. Oh, I have a question. Somebody give me an answer. What do you say to a client who says, I brought a friend in to sit in with me during this consultation? Maybe it's your first consultation. This is being recorded, so if you are brave enough to answer, you have to say something loud enough for the mic. Judge?
I tell about the attorney-client privilege is number one. So I learned my lesson from Judge Lodge on that.
Oh, okay, okay, hard one. So you'd make sure the client knows that they're waiving the attorney-client privilege. Yes, very basic, very important. Anybody else? Anything? Yes,
I usually ask to speak to the client alone first, or at least for the first 5 minutes to explain that without the other person present, so that they're aware and they're not influenced by that.
good. All correct answers, and I think it's important that clients feel comfortable in your office, and it's important that that they have the moral support by somebody they bring in. And I've done that little speech without the person involved in the room, with the person involved in the room. But I want you to know that I had this awful experience. I told my client, attorney-client privilege, basically you're playing who do you trust? Oh, this is my lifelong friend. But found out, oh, I don't know how many weeks later, that her lifelong friend has been sleeping with her husband. So nothing's full.
So did you represent the husband?
No, but I will tell you, we had a very nice result at trial because you were the judge.
Yeah.
Gonna switch subjects here a little bit. I'm gonna talk about no bias here, the abysmal way we family law lawyers keep moving on documents. For 6 years, I taught a course at Clark College in family law. And because my course fell on Mondays and we had to find some other way to make up the time, I just said, class, you have to, well, and Mondays had holidays like Martin Luther King Day and President's Day, so that's why I had to make it up. So I said, in lieu of having these extra classes, you have to attend 3 dockets and write a paper about the dockets, family law dockets, and they did. And we talked about their observations, and they said, how come attorneys are so rude to each other in court? Why does the court let them get away with that? They act like children. Don't clients expect more from their lawyers? And I think we interrupt each other at bar. I think some people among us have unnecessarily loud voices. They act, or we act like every point we're making is poignant and the centerpiece of our case. Most distracting, those of us not at bar, mill around the courtroom, chatting up friends. I'm guilty of that. It's chaotic. And the result, I think, is profound disrespect for the process by the people who witnessed it. If they don't witness it, they don't know about it, and we still get their respect. So I guess my question is, do you agree with basically what I've just gone over? Yeah, you do? Okay. Speak up if you can answer. Does anybody have any ideas why we do this or what we can do about it? Very hard for those of you on Zoom. I've discussed.
I was gonna say, it's what people expect from watching us on TV.
Oh, okay, so we feel, attorneys feel a need to misbehave to satisfy the client expectations.
I think that you put on a performance sometimes in court because clients are expecting that.
Okay. I'm sure that's part of it. I've discussed this problem with attorneys from time to time, with judges from time to time. I think judges feel the attorneys need to take the lead. It's our bad behavior after all. And I can speak for myself. I think it's a judge's courtroom. They need to take the lead. But all pari delicto. We're all equally responsible for the situation. And one of the things that I think contributes to this is that some lawyers are still there at bar arguing to convince their opposing attorney. And as representatives, we rarely have to convince the other attorney. what we need to do is convince the judge. And the judge doesn't want to hear a bunch of crying babies screaming at each other. I can tell a story on Judge Nichols.
Please love that.
Correct me if I'm wrong, but I was involved in a hearing with another attorney. And you didn't like how loud the presentations were. And you said to my opposing attorney, "Are you yelling?" And my opposing attorney said, "No, I don't think so." And he said, "Oh, but I think you are." And the arguments of counsel continued the presentation. And you stopped and you said, "You know, if you keep yelling, I'm going to take you at the end of the docket." Of course, I'm sitting here, why should I? But you got your desired result. The volume went down and you heard the arguments and made a good ruling. Oh, very good ruling. I don't really actually remember the and
I did have to use the timeout room once too.
you did, okay. Well, that's where is the timeout?
At the end of the docket.
Okay, well, you know, the old adage that if you don't have the facts on your side, you pound the law, and if you don't have the law on your side, you pound the facts. And if you don't have either one on your side, you pound the table. And I keep thinking, isn't it like Judicial College 101 that a judge knows when you're pounding the table that you don't have a case? So anyhow, I had an interesting experience. My brother is attorney in Southern California who does Chapter 11 bankruptcy cases as a trustee. High-end cases. He's much more successful in his own mind and in the bank than I ever am. But I admire him for a number of things. He recently had a case where there was a nationwide debt relief attorney firm that was doing things fraudulently. One of the principals was actually criminally prosecuted and convicted for fraud. And so their business had to be taken over. The clients subscribe to the service. So it's not like pay once and you get your debts relieved or whatever, but it's an ongoing monthly income. And so these clients had to be served. And so my brother was asked to, or took the job of, taking over the business, making sure it was done legally and done properly, and clients were getting their paid for services, etc. My brother's boss is the United States trustee. And the United States trustee was getting messages from Washington that that business my brother was managing had to be shut down. So my brother resisted being shut down because where would these clients who already paid their money get the services they paid for? So lots of emotion involved in this federal case, lots of parties of interest, briefs filed, including the day of the hearing. And I observed that when the judge took the bench, he had read everything. So this, of course, he's on the record. He says he introduced all the parties and their attorneys of record. He noted certain participants in court and on Zoom and their role in the proceeding. Some of the witnesses actually did appear by Zoom, and that's how I got to observe it. I was participating or listening on Zoom. The judge said he had read all the pleadings, including those that came in the same day. He summarized his understanding of each stakeholder's position, which served to make it very clear he was indeed fully informed of the case. So he didn't just say, you know, Mr. Marshack, I've read your brief, make brief argument. He told me what my brief was. So he preempted my argument, so to speak. He said he would hear from all parties in due course, but would allow the sides to make argument on their points at each stage of the proceeding. He chose the order of presentations. He directed the flow of the hearing by letting them know specifically what he wanted them to address. And if he said, Mr. Marshack, I want you to address A and B, and I spent 2 sentences on B or A and went on to C, D, and F, he would stop me and say, that's not what I want to hear. I asked you to address this point. And sometimes he would go throughout the proceeding issue by issue. He challenged the attorneys on some points politely and would try to convince convince me of your position because I have these doubts. And so the attorneys always addressed the court. They didn't address each other, except occasionally to give courtesies. They spoke only when given leave of the court to speak, and again, always respectful. And I was thinking, my God, why can't we do that? And one of the reasons is, of course, that judge, that was his all-day case. We can't do our docket, we can't hear 30 cases and get at that kind of time. But on the other hand, our county has more than double the number of judges it had when I started practice 35 years ago. So I don't know why you can't do that. Anyway, it's something to think about. A good attorney has to be able to tell clients the truth about their chances in court and when to simply say to their client, no, I don't want to make that presentation. And what comes to mind is when I had a client who lived and worked in the Philippines. He made $1 million a year as a salary. Casinos and stuff like that in the Philippines are a big deal. He had armed cars, he had a security team like nothing. And he kind of dressed like who runs Facebook? All of a sudden I'm blanking his name. Yeah, that's right. Black t-shirt, that's his thing, jeans, that's his uniform. His family lived in Puget Sound area, and that's where the case was. And so why he wanted me for his lawyer, I don't know, but we ended up arbitrating the case. He was getting very frustrated that we weren't getting closer to settlement. And his wife had the 2 dogs. So he said, well, I know. Let's make a motion that I get one of the dogs. Now that's ridiculous. He lives in a high-rise penthouse. He has no yard for the dog, but he's out. And he's used to getting his way. And the dogs now live on a bucolic farm. Tell me, does he have a chance? Except for his ego, his reality-bending ego. It's pretty hard. So I told him all the ways that this would boomerang on him. And if he thought he had a tough negotiation now, he'd have a really tougher negotiation after that. And he finally, it's same. And he backed off. He's an incredibly good guy. And he and his wife talked on the phone a few weeks after that. And they had the beginnings of a settlement. And we did settle the case. We all as lawyers have this difficult tension. We owe a duty of loyalty. This must be my book. Sorry for that. Owe a duty of loyalty and no conflicts of interest with and confidentiality. That's what I want to say, confidentiality to our clients. And we also owe a duty of candor to the court. So that is a tension that we live with every day. And it's very difficult, and our clients don't give a rip. they don't want to hear our little problems while we charge them 300, 400. What is it getting to be these days? Now, to hear about our sob story that, well, we gotta be honest with the court. We gotta, we practice with a code of ethics, and I'm not going to say this to the opposing attorney. Excuse me, but everybody in this room lives with that tension, and you're professional, and that's what you do. And so I would like, and sometimes I felt, a strong bond with attorneys because we all share that. I could always tell when Scott had a very difficult client, well, partly because Tammy would confess. But Scott, his card's very close to his chest, and it's a little difficult, but I often fantasize, now what can I do to ratchet things up for him in his office? There was a time when he and I settled the case, and I prepared the final papers, and I had mistakenly awarded something that my client by agreement was to have, and it went to his client. And we didn't discover it until weeks, maybe months after the papers had been entered. But when it came to my attention, I think I was the one that discovered it, God knows why. I called him up and I said, Scott, we've got a problem. I didn't say I had a problem, I said, we have a problem. And he looked at it and says, well, I remember that, you're right, that wasn't the agreement. And he facilitated getting in the amended papers. And that's the kind of relationship that all of us should have. And I appreciated him so much for that. I had another experience where a client of mine in a deposition, Carolyn Drew was taking his deposition, and it was on relevant issue, but not really a core issue. That she asked him a question and he gave an answer, the same answer he'd been giving me all this time. And a few days later, he said, I have to tell you, Howard, I lied in the deposition. And I thought, oh, that's bad. And there wasn't a sure thing that would come up at trial, but I had a pretty good idea that since the case went to trial, it was going to come up. So I asked him, I told him that if it comes up, I cannot elicit testimony that is a lie. And I can't argue an argument that's a lie. And if it's found to be that you lied in the deposition, that may not be the only thing a judge thinks about. You might think your credibility is shot on all these other areas that are important. And he wasn't exactly proud of himself for lying, so he agreed with me. And so at the commencement of trial, I said, I would probably get the testimony and arguments. I have something I want my client to has allowed me to say. And I said to the judge, there was this issue that came up in deposition. This was the question, this was his answer. That is a false answer if he wants to make amends. And I thought that would be the end of it. He did get punished. It was an attorney's fee fine. The judge thought he was credible. We got a fairly decent result. And I think the attorney's fees could have been overturned on appeal, but he didn't want to appeal. So that was unexpected. My opposing attorney and the judge said, Howard, that was an amazing thing you did. And I just thought, God, I was just getting out of a foxhole. If I was a great attorney, he would have never lied to begin with. But anyhow, my uncle Don Launder was the presiding judge in the Multnomah County Circuit Court for a number of years. Not exactly a terrific guy in the family, but he, but unexpectedly, but by the time I graduated law school, he had divorced out of the family. But he sent me a message on my graduation that I thought was the nicest piece of advice that I got in my new professional career. And that was to practice law within your personality. You know, wasn't a screamer, didn't pound the table type of thing, and, you know, I'm being a new attorney, even though I was the ripe age of 33. I thought maybe, I need to be aggressive to make my points. And his message to me was that I don't have to be. So I appreciated that. So be yourself. If yourself is not being a screamer, that's good. You don't have to be. If yourself is to be a screamer, be yourself, just know it's off put. Let's stretch this out. Judge Morgan told me there's always three things to what you do: a deposition, a trial, a docket matter. And it's the one you planned, the one you did, and the one you wish you did. And so figuring that you didn't do all that you wish you did, maybe there was a mistake in there somewhere. So what do? You think about it, think of ways to improve and move on. But Scott never learned from mistakes, did he? He had to make them before he could learn from them. I don't think he ever made a mistake. Judge Collier said something interesting. I think as a family law lawyer, he said that because he used to have a family law practice and he presided in family court for a long time. And when he became a Superior Court judge and he sentenced defendants to maybe 10 years in prison, he found that they accepted that with a lot less fuss than when he denied a fellow, you know, 2 days, 2 overnights a month with his kids. And we just deal with that kind of outsized emotion in our practice. That's what we ought to manage. But if you have Nancy's touch, you can manage. Scott isn't here, but he sent me some of his thoughts that might get mentioned here today, so I'll mention them now. He said what it really comes down to is having pride in your work. And that mentors have a large role in instilling people to have pride in their work. And he suggests, don't be afraid to go to judges after trials and ask for a critique of your materials, written materials. When I once in the family law annex, I ran into Judge Milnick, and I told him I could never be a judge because I don't have the reading speed to read all the materials that judges get handed. I'm a very slow reader. And he says, well, your declaration today was much too long. It was within the rules. What do you mean what's too long? It's too long. Well, what part should I cut out? He didn't have a word to say about what I should cut out. We attorneys are clueless about what really is going to impact the judge. If I cut out this thing, well, maybe that's the most important thing to him. So, Judge, what can we cut out of our declarations? Do you have any idea?
Yes. All the hearsay.
All the hearsay. All the irrelevant allegations. She had an affair, he had an affair.
There we go.
Okay. Scott says to recognize it when you need help, particularly with expert witnesses. And I always had kind of an Achilles heel when it dealt with the issue was business valuation. The math involved, the concepts involved, I had to really learn them with every case. And Scott said, me too, when I confessed that to him, but I don't believe it. But I learned that my expert witnesses could give me a roadmap to their direct examination. They could tell me the weak points that I can get on cross-examination. And sometimes they hang around and comment on the other experts' testimony. But never be afraid to ask your experts for help, or your fellow attorneys for help with experts. Then Scott says, meet deadlines. How many of you think that's a bad piece of advice? Meet your deadline. Scott says that try to develop working relationship with lawyers so you can do what he and I did. We developed a spreadsheet for assets and debts that I think became commonly used. So he thought that's a good thing. Let's see. What was it? Page limits. Is it still the rule that you have to say basically your case in chief in 6 pages? That's no longer the rule? Never mind.
Family law.
Pardon me, it is
For family law.
for family law, okay. Well, in family law, we have multiple issues. Especially if you're the respondent, you have to manage a whole lot of content within 6 pages. And I came up with a paradigm that I thought was pretty good. You could almost do it, and sometimes I did do it in bullet point fashion, which I hope the judges appreciated. And what I would have my clients do was, as their homework, I would have them write me what each allegation was that they disagreed with. And then a brief statement below that that said either it's true or no, either it's false or it's misleading. If it's misleading, how is it misleading? And then a concise description of what really happened. And then lastly, a brief statement to point out any proof, like is there an email message or is there the certificate or document or something that proves their side of the case. And then I would edit it down so that everything, we got massive allegations responded to in a very brief and hopefully convincing way. I always had difficulty when I was awarded attorney's fees in court. Those few times I was awarded attorney's fees, when I had sent the client a bill for $2,000, and you would say, well, Howard, you want an attorney fee award, but the judge said the reasonable attorney fee was $300. Do any of you have a good explanation I could give my clients if I ever have that situation again? So all I could tell them was the judge didn't want to punish the other side harder than he already did. So, and yeah, so there's a lot more effort than going to attorney and practicing judges. Think about that. We are in a stuck position. So say something that we could take to our clients. How many of you here have in your personal capacity been given a summons to appear in court? You have. I did when my wife Marshack 1.0 decided to divorce. And suddenly somebody by the name of Gonzalez or let's see, Mr. Sasser was going to make decisions in my life. Fortunately, I knew that. They sent my case to Cowles County. But most people don't have that. Most people, they find some strangers could be making a lot of decisions and that their opposing party hired a lawyer that is describing their case in ways they barely recognize. And they're making all kinds of requests and allegations. Do I need a lawyer? Yes, I need a lawyer. They want $350 an hour. Is that what the going rate is these days, by the way? What? How am I going to afford that? Even if I win, I lose. So someone really ruins somebody's life. And it's an important and a useful tool. It's a necessary tool. The rules require it. But my point is that we lawyers have to realize that these things, what we do routinely every day, impact people in ways that we can become immune to. So think about that. And you shouldn't issue summons for tactical or vexatious purposes. There's a rule about that. Let's see. let's see, most of the time I thought sending out 100-page, 100-item set of interrogatories was wasteful and stupid. And other times I thought, well, how difficult can it be for somebody to flip through some pages and say no, no, no? Because in family law, we have just a huge, wide, broad variety of things that we have to cover. And if we never ask the question and it ends up being a problem, then our license is on, well, our malpractice is impacted. And sometimes your client doesn't know enough to be able to tell you what's an important question to ask or not. But sending out interrogatories and other kinds of discovery is an important part of the case. And it really should be tailor-made, because otherwise it really is running up the fees. In 2006 or so, I took over a number of cases from a retiring attorney, about 12 cases. And in the week before I received those cases, he issued full panoply interrogatories to every single one of them. And of course, I was left with the job of fielding the answers and doing whatever it is he started. And interestingly, every single one of their trust accounts had been drawn down to zero. They didn't know him, and they didn't get any money coming back. And that is clearly a wrong use for interrogatories. When I represented Ken Weber in his divorce, a well-known, highly respected, one of the best family law attorneys around. And when I say I represented him, that means when I did what he told me just now to go do. He asked me to gather up all of the firm's financial documents that people would ask for in interrogatories for the last 3 years, and he got permission from the stakeholders in the firm to send them out to his wife's attorney. So I carted them out to his wife's attorney. And the attorney hadn't even given or sent out interrogatories yet. Here you are. How many people here think that was a bad idea? Raise your hand if you think so. Oh, I'm gratified, because many years later, when I went through a divorce, that's exactly what I did. By the way, it was the same attorney that we had to hand the papers to. My good friend, Ray Young. Okay. 5 till 1. I could either go down another page, which frankly is Tom Phelan's topics, or I could ask if there's questions. I prefer to ask if there's questions. Any questions? Oh, that wasn't that.
I have a question.
Yes, Nancy.
What was your toughest ethical quandary? Or did you share it earlier about the client who lied in the deposition?
I think that was it. Yeah, that was it, because that had a lot of heavy consequences. Yeah, good question. Yeah. If something else comes to mind, I'll email you. Yes.
You changed careers to become a lawyer.
Yeah.
You mentioned that. Did you find your legal career to be as satisfying and interesting as you had expected at that time?
I was a master's degree social worker, placing kids in foster care and group homes. And my parents had cajoled me for years to become a lawyer. And so at some point I said, if I'm a social worker doing this for 3 whole years, and I'm going to give up the idea of going to law school. So as that deadline approached, I decided to go to law school. And my parents made the best decision they possibly could for me. I loved the practice of law. So
You were talking about being a participant when you were going through your divorce
Yes.
and trying to anticipate the questions and things like that. I had the same type of experience. I was called to be a witness at a disciplinary hearing. So I was being cross-examined. I asked the question, the other side objected, I said overruled. I just blurted it out. And the hearing officer looked at me and said, I said, just trying to help out here.
Well,
He agreed.
no, okay, so you're sustained.
Yes. But it was kind of embarrassing.
Any other questions? Yes, ma'am.
I have another one. You've spent quite a bit of time volunteering your services, and as I understand it, continue to do that. I wonder if you wanted to say anything about your experience being a volunteer lawyer.
Okay. I don't volunteer as much as I plan to with volunteer lawyers. I didn't plan on peddling back my hours. I just haven't given them the phone call to say, give me clients. But I have to say, I feel like all the hours that I put in there are not very useful. It's been not a very satisfying experience. The people at the Volunteer Lawyers Project to a person are wonderful, very helpful. They facilitate everything. I think I ask them too much and work them too hard, and they seem cheerful the whole time. But clients give up very quickly. I think if clients find out that they're not going to get a representative in court, that they just go for a period of time and then fade out. I even said, look, I'll do the paperwork for you. All you have to do is make sure that everything's true and you know, participate along the way, but I'll do the paperwork. And nothing, I don't feel like they gained anything from my effort.
Can I speak about that?
Introduce yourself, please.
I'm Jesse Anderson. I'm the legal director at the Volunteer Lawyers Program. Howard is the top name on our list for new attorneys who would like to volunteer and would like to learn family law and just need that mentor or that person to talk to and call because they feel confident that they know every answer yet. And so, I definitely understand and hear what you're saying, Howard, but I hope you know that we at the Volunteer Lawyers Program feel like what you offer to the program and the new attorneys that come up in this community is so much beyond what that individual client gets. Because your mentorship for folks and having your name as somebody that's willing, and not just willing, but enthusiastic at the idea of mentoring people is extremely valuable to us.
Well, appreciate that, and I'd love to continue to do that kind of work. Nancy and I talked a couple years ago about maybe doing some mediation through volunteer lawyers. There's some very tricky ethical rules that would have to be worked out, but then the renters crisis hit you all, and there was no room to have that discussion. But if there becomes room to have that discussion, I'd like to be part of it.
Yeah, you definitely will.
I think we're done unless I have to tap dance for anyone. Thank you very much. Once again, it was truly an honor to be asked to do this. I appreciate seeing you all again.
There you go.